A decade-long three-state legal battle over water rights could conclude this summer as the U.S. Supreme Court heard arguments this week from attorneys representing New Mexico, Colorado, and Texas. The states presented a plan that would split the Rio Grande's water below the Elephant Butte Reservoir. New Mexico would receive 57% and the other 43% would go to Texas. The plan was announced in late 2022, but the federal government pushed back the following year. Federal officials say the proposed solution would violate the 1938 Rio Grande Compact, an 86-year-old agreement that first split rights to Rio Grande water between the three states. It's a complex case and one that Source New Mexico's Danielle Prokop has been untangling for the past few years. Danielle joins me virtually from our nation's capital to break down how the Supreme Court could write the last chapter in this water rights saga. Hi, Danielle. For those who haven't been following the case closely, can you break down exactly what this case is about?
Absolutely. Thanks for having me. So the case has evolved over its 10-year run in the Supreme Court. Originally, Texas took New Mexico to court over groundwater pumping below Elephant Butte Reservoir, saying that when groundwater is pumped, it is taken out of the river, even though it's owed to Texas. So that was the original case. It then changed a little bit as the federal government joined it in 2018. They joined as a party, as an intervener, unanimously granted by the Supreme Court. And that's kind of where we end up today, where now the states are on the same side, proposing a deal to end the dispute over Rio Grande water between Texas and New Mexico. But the federal government is objecting to that deal. Those were the oral arguments that we heard Wednesday in the Supreme Court.
Okay, about those oral arguments, I know that you were in the courtroom. What exactly were those specific arguments, both from the federal government and the coalition of states?
Absolutely. So the federal government went first, and we heard from Assistant Solicitor General Frederick Liu, who presented the case. He argued that the deal should be rejected because it proposes something that is objectionable to the compact and to the operation of the Rio Grande project. That's that network of federal dams, canals, drains, ditches, all from southern New Mexico extending into Texas. It's what allows the federal government to deliver water to two regional irrigation districts, one in New Mexico, one in Texas, and to Mexico under the 1906 treaty. And so he argues that the deal is imposing obligations on the federal government that they don't agree to, and that it cannot be settled without their consent as a party admitted to the case. Now, Texas and New Mexico have a very different argument. They say that the compact is, or that they say that the deal is okay under the compact. They further say that the project is subject to the appropriation. So I know those are some complicated words, but it basically means that the amount of water that is designated to New Mexico, the project has to use that amount in their calculations, not the other way around. And then finally, that any disputes that the federal government has with the operation of the Rio Grande project in southern New Mexico can be administered through federal laws, whether that's reclamation law, or through the state adjudication process. That's the way that we determine what order water rights are in.
Okay, thanks for that. Now, is there any sense from how the justices questioned the parties during those oral arguments as to how they might be leaning? I know Justice Gorsuch in particular seemed to have shifted his stance from earlier.
Yeah, so when the federal government was admitted as a party in 2018, it was a unanimous decision from the federal court, which overrode the special master in the case. That's the judge appointed to oversee the case as it moves through a trial-like period. So they overrode the former special master and admitted the United States as a party. And specifically, they talked about how the history of the Rio Grande project and the Rio Grande Compact, that's the legal agreement that splits the river between states, are inextricably intertwined. And that and noting that the federal government's arguments often mirrored Texas, and they were looking at the time for the same sorts of relief from the court as Texas was. And so when Frederick Liu was telling the court yesterday that as a party, the federal government had a say in whether or not this could be settled, Justice Neil Gorsuch was really pushed back on that. He said that, "I've got to say, you're making me regret that decision," as a direct quote from him. And so the other people who were skeptical of that, the other justices who were skeptical of that, included Clarence Thomas and a little bit of Chief Justice John Roberts. Two justices were quiet and didn't ask any questions. That was Justice Amy Coney Barrett and Justice Brett Kavanaugh. But on the other side, there were also a lot of tough questions for the states and their role in the deal. Justice Elena Kagan and Justice Sonia Sotomayor had some really tough questions, trying to understand what the role of the project looks like under the essentially a new compact. And the justices are trying to weigh several questions. This idea of state sovereignty on water disputes and the federal government's operation of a treaty and reclamation project. They have to determine whether or not the deal impermissibly disposes of the claims of the federal government, and whether or not it really imposes these obligations the federal government says it does. So we're going to be waiting for that decision through June, but there was definitely some indication of how a few of the justices may vote, but it really leaves it up in the air.
Understood. Daniel Prokop from Source New Mexico, thank you so much for joining us from Washington, D.C.
Take care.